7, and the question is that Part 2 stand part.
Mr. Chairman.
The Honourable Phil Goff.
Mr. Chairman, I'd like to address specifically clause 32 of this bill, insofar as it makes a change relating to coroners' inquiries into Defence Force personnel killed while on operational service as a result of hostile action. The status quo, sir, is that the coroner is able to report on deaths as a result of enemy action by New Zealand Defence Force personnel out on service in an area such as Afghanistan. And what this bill does is take away the coroner's right to provide independent scrutiny and produce a report that is accessible to the public. Those are the critical points, sir. What the coroner enables us as members of Parliament and enables members of the families of armed service personnel who are killed in action and allows the public to do is to have an independent person scrutinise the causes and circumstances of the death of that personnel and to provide a report that the public have access to. Now, the reason why this has been brought to the House in this bill is because the New Zealand Defence Force took umbrage at a report by Coroner Ryan into an incident in 2012 where 3 members of the New Zealand Army were killed in an improvised explosive device incident in Bamiyan. Corporal Luke Tamatea, Jacinda Baker and Private Richard Harris. And I've read the report by Coroner J.P. Ryan, and I've got to say, Mr. Chairman, it's an inoffensive report. It does not in any way intrude on issues of national security, though that is the pretext why this amendment is being made to the bill. The coroner's report is available to all of us. Any member of the House can look at that, and there is nothing in that report, I argue, sir, that could in any way be regarded as jeopardising New Zealand's national security. The second argument by the New Zealand Defence Force is that these matters are non-justiciable. That is, the coroner, as a legal figure, has no right to second-guess the decision that is made by a commanding officer on the battlefield. And I don't believe that Ryan's report does that either, sir. What I do know is that unless you have the right for a coroner's report, there is no mandatory requirement for the investigation into the death of a soldier on the battlefield. And that point is made in the memo that I have briefing the Chief of Defence Force. So the coroner's inquiry is the one mandatory requirement that the death of a soldier in action should be established, the cause and the circumstances of that death should be established. The Defence Force can, of course, hold a court of inquiry, but that is not mandatory. Secondly, sir, when the Defence Force holds a court of inquiry, its decisions and its reasoning is not available to you or I, or, most importantly, to the families of the soldiers killed, Mr. Chairman. And one of the strongest points that I have read was made, in fact, by the partner of Corporal Luke Tamatea, who herself is in the military, and she makes the point very, very strongly that she and her family took reassurance from the fact that an independent person interested in finding the actual causes of the death and not interested in protecting the reputation of the Defence Force had looked at this and had given information to the family. And I say, why should we as a House deny the members of the families of soldiers killed in action from receiving such a report?
Sorry to interrupt the honourable member. The time has come for me to report progress.